दूसरा देख जी फुए ऑर्डर शीट Pursuant to the notices, कुछ किसी ने कुछ फाइल किया है? कोई आया है? जरा बताएं.
They have submitted the replies.
कौन किसके लिए है? Who's for number one is Lieutenant General retired Faez Hamid.
But I am appearing for respondents numbers 3 and 4.
नाम बताएं please.
Lieutenant General Faez Hamid and Mr. Brigadier Rampian.
Okay. Have you filed anything?
Yes, I filed my response to the
CMA number?
267 and 268. 267 is of Lieutenant General Faez Hamid.
267
and 268, CMA number 268.
Do you admit or deny the allegations?
The allegations have been denied, my lord. They are specific allegations, they were highlighted.
We'll come to you.
Yes.
Just let's just do, as they say, homekeeping. Now, who's, anybody else file anything or no? Okay.
Yes, I.
And कौन रह गया? अच्छा, we had also issued notice to our former registrar. He has also filed something.
I'll reply.
आपने पढ़ लिया है?
जी जी.
अच्छा, what does he say? Support or deny?
He doesn't say anything. He says, I just brought to the notice of the Chief Justice that this is what he has done.
सज्जाद साहब ने भी कुछ फाइल किया.
आप भी इस केस में?
जी.
Find a reply on behalf of retired Justice Kasi.
नंबर
253, 254.
ओके, इसका नंबर लगवा लीजिए. अच्छा, ओके, 253. ये डिनाइल है या
मतलब उन्होंने एक कॉपी है जिसके साथ रेलेवेंट डॉक्यूमेंट्स भी लगे हुए, लेकिन वो फॉर सम रीजन रिकॉर्ड में नहीं है.
नहीं, आपकी इसमें तो कोई डॉक्यूमेंट नहीं लगाया आपने.
जी, वो कुछ सम कंफ्यूजन मरोड, बट द रिप्लाई इज 253.
Are there some documents attached with it?
जी सर.
You are saying there are some documents attached with it?
Some documents, relevant documents, which have been attached to a separate paper book.
Where is that?
Apparently is not on the record, so we'll have to file that.
Can you give it? We'll make photocopies.
That's not part of the paper book which has been. That's not part of the paper book that has been.
We said they were left out.
इन्होंने रेफर किए हैं.
I don't know what they are. Let's make इनकी photocopies बना लें. इनकी कोई ऐसा करें, कोई 5 और कोई 10 बना लें. ठीक है. अच्छा, ठीक है. Now, where were we? So you deny the allegations. Answer. How should we proceed now?
Sir, it only makes my case clearer that this was a case where factual inquiry should have been held by Supreme Judicial Council. Now they are denying the allegation I made in my replies, and they have denied them. All the more reason that there should have been an inquiry in which I would have summoned them as witnesses and cross-examined them to establish what I was alleging was correct, or it was otherwise. So therefore the case is very simple, that no report can be submitted by the Supreme Judicial Council before the President without holding an inquiry under Article 2096, which in this case was denied. To the President. What I'm submitting, that Supreme Judicial Council cannot submit a report to the President without holding an inquiry. The report has to be based on inquiry.
What was the allegation in the against you?
The allegation is that he made a speech. He made a speech before the District Bar Association Rawalpindi, in which he disclosed what has been going on. And in that
How do we proceed further? How would you plead your case now? What should we do if we just want to hear your point of view on this?
It's a simple case where the whole order should be quashed because it was based upon a report which was not based upon inquiry. Kindly, I take your lordship through Article 209, very clear on that. There is no ambiguity on Article 209.
Which part of it?
So let's see the clauses 5 and 6.
Yes. Please read.
If on information from any source, the council or the president is of the opinion that a judge of the Supreme Court or a High Court may be incapable of properly performing the duties of his office or by reason of physical or mental incapacity, or may have been guilty of misconduct, the president shall direct the council to, or the council may on its own motion inquire into the matter. On its own motion. So now there are two ways. One is presidential reference. The other is the council may on its own motion. Now this is a case covered by the second portion, on its own motion, because the registrar was a complainant and the Supreme Judicial Council, registrar as secretary of the Supreme Judicial Council became a complainant. And on the basis of that complaint, the Supreme Judicial Council decided to proceed in the matter. So what they needed to do is inquire into the matter.
How should they inquire into the matter?
By holding a factual inquiry on the allegations that were there.
Was any factual inquiry held?
Never.
Yeah,
That's my private.
This is an admitted fact.
It's a fact. And they
where is it? Is this admitted fact that no inquiry was held by the SJC?
मतलब ये जो है
Is it admitted fact or not admitted?
एडमिट कर लिया था जिसकी वजह से जो है
No, देखें, there are two aspects to it. Na? One is the speech.
जी मालूम.
The other is the content of the speech. See, as far as the speech is concerned, he's not denying it. He said, I did make this speech, but I made it, this is their case, that since nobody was paying any attention to me, so I went public. Whether this in itself constitutes misconduct or not, that's one, leave that aside for the time being. We are simply asking you that the allegations that were leveled by the petitioner, were they inquired into by the Supreme Judicial Council or not? Is this true or false?
No, my lord. उनकी allegation की नहीं की गई, जो कि
नहीं, बस ये पूछ रहे हैं. अच्छा, and now please go to what you said, 2096.
Yes, sir.
Khan Sahib, you were referring to another provision.
Yes, sir. The other is clause 6. If after inquiring into the matter, so this is very important, if, after inquiring into the matter, the council reports to the president that it is of the opinion that the judge is incapable of performing the duties of his office or has been guilty of misconduct, and that he should be removed from office, the president may remove the judge from office. So, sir, the council can only report if it has held inquiry into the matter.
Can you read 7 also?
7. A judge of the Supreme Court or of a High Court shall not be removed from office except as provided by this article. Meaning thereby, on the basis of a report which has been made after due inquiring into the matter, that only in that case, if there is a report in which he has been found guilty of misconduct after full factual inquiry, only on that basis he can be removed, cannot be removed for any other way. Otherwise,
going along with you, I just want to understand one thing. It's being conceded by the Attorney General that there was no factual inquiry. Now, moving ahead, what can we do? What can this court do?
That means that inquiry, that report by the Supreme Judicial Council on the basis of which he has been removed is unconstitutional, because Constitution requires...
I'm not asking for an argument. I'm saying what can this court do? What if I was to ask you, okay, what sort of order can this court pass? What would you suggest?
Declaring the inquiry, the report of the Supreme Judicial Council as unconstitutional, void, and nullity.
And suppose the allegations that you level were not true, then
What was it?
suppose that the allegations that you leveled, one person is saying no, one person is saying yes. Now we must have a mechanism to ascertain who is telling the truth. I mean, we can't throw a coin in the air and decide on that basis. So there are two possibilities. I mean, don't mind my saying so. Either the petitioner is telling the truth or is not telling the truth. There are only two possibilities. If, don't mind my saying so, if he's not telling the truth and he makes this allegation, and on that, and nobody ascertains, like you have alleged that nobody ascertained, and nobody ascertains whether his allegation is true or false, and is or whatever the order is set aside, surely this will not be proper. That's why I'm saying, how do we go forward now?
That is exactly the case. If your Lordship may kindly see that I informed the Chief Justice of
No, we understand that. They concede no inquiry was held. I'm saying, where do we go from here?
So therefore, the entire proceedings against me.
वो भी हो गई. Suppose, just for the sake of argument, we say, because we have to deal with these cases, it becomes precedent. Okay? Supreme Judicial Council, let's assume, did not do its job by inquiring into the matter. Correct? I think fundamental rights are available to judges as well. The due process and fair trial. By all means, hear it and then remove me. Because say this is false allegation you've leveled, you don't fit to be a judge, and not only made a false allegation, you went and made it publicly. You would imagine, if it was false, he should be removed. If it was false, he should be removed.
No.
No, if the allegation that you make now
Yes.
is established to be false after the inquiry,
Yes.
should you have been removed?
Then can be yes.
Okay.
Then that
No. Now I reverse it.
Yeah.
If after inquiry it transpires that the allegation that you leveled was true,
Yes.
they may say you still should be removed because you went public. Or, no, you should not be, but your emphasis is on the fact that one way or the other, inquire into the matter. Am I correct in understanding that? Now because you had leveled initially allegations without making anyone a party, so we wanted to hear what the persons against whom the allegations had been made, would they say? They may come and say, yes, I did so, but there was nothing wrong in it, or simply say, yes, I did it. But the matter can't end now because they're saying, no, this is all false. So who will ascertain the truth of the matter?
The Supreme Judicial Council ought to have done that. That is what my position is.
Now.
No, now your Lordship is.
जरा मैं solution भी बता देना साथ. We're looking for how to solve this riddle.
इसका simple जवाब है सर. जैसे पहले, in some cases it has happened. एक तो ये है जो हमने to begin with
नहीं, हमें solution हम आपका point of view समझ गए, हम आपका case समझ गए. अब हम करें क्या ये बताइए. What sort of order which should not, either then it will amount to the same allegation that you've leveled on the other side. The other side will tomorrow complain and say, you never ascertained this fact, and you've held that we've done this thing. So, we come up with a solution now.
Sir, my solution is
Yes.
Okay, let this order of the President and the report may kindly be quashed, and a commission may be appointed to ascertain the truth, so that we can cross-examine them, they can cross-examine us.
Second, you know, commission, how, under what law will we do that?
This honorable court can always do so.
No, they can't.
To ascertain the truth about the matter.
No, it can't be remanded to the Supreme Judicial Council.
Sir,
Is that a possibility or it's not?
it can be, yes. It can be, yes. It can.
No, I want your clear thinking on this.
After questioning the order of
Sub-article 7
President,
Sub-article 7
there is one problem which I see.
एक Sub-article 7 भी पढ़ लें 209 Sub-article 7 209 Sub-article 7 पढ़ लें
जी 7 साहब वो 7 की बात हो रही है ना, तो उसमें है a judge of the Supreme Court or of a High Court shall not be removed from office except as provided by this article. Article क्या provide करता है? President can remove on the basis of a report. The report has to be based on inquiry. So therefore under clause 7
नहीं देखें,
He could not be removed.
ये तो admitted fact हो गया that no one ascertained whether the allegation was factually correct or not. That much is established from what I've been able to understand. Unless somebody says, no, it's not been established. I don't think even Khwaja Sahab, पूछते थे Khwaja Sahab कहाँ गए? Was the one way or the other whether the allegation was true or not? Was it being ascertained or not?
It was never inquired into, it was never ascertained, and if that part of the order would not carry.
How do we go forward then on this?
May I very respectfully submit?
Because, you know, both can't be telling the truth.
No, quite right. May
Yes.
I very humbly submit, my lord. The order itself may have two components, although they are mixed up. As far as I am concerned, they are mixed up in the sense, one is with respect to the public speech that was made. Whether the public speech that was made.
That's a separate aspect.
This is what I'm saying.
That may in itself be such a grave crime that you remove him.
No, I'm making a suggestion.
Or nothing implied in the order is the fact that you've leveled such serious allegations against some people.
Which cannot be sustained because no inquiry was held. That portion.
What is the solution here?
May I very respect, this is what I was saying, madam. May I very respectfully submit, the order itself is composed of these two components. One is that a public speech was made. The other is that there was an allegation made or there were some assertions made which were not inquired into, and that was also held against the petitioner. Now that portion cannot be held against the petitioner so far as the STC order is concerned, because that was never inquired into. We are only then left, as far as this list is concerned, only left with the question whether the public speech that was made was.
नहीं देखिए उसका बड़े implication होगा. I think let's live in the real world. The entire eyes of the nation are before us. There are 2-3 constitutional offices involved. One is at stake is the independence of the judiciary. If I'm sure you will also agree that no judge should be removed without cause. I'm sure you will say that.
Yes, quite right. That's true.
That's one aspect. The other aspect is there's another constitutional body involved called the Supreme Judicial Council. Now, the Supreme Court should not interfere in the work of another constitutional body unless there is something so manifestly unconstitutional or unjust. What Mr. Hamid Khan Sahab is saying is there was no inquiry held, and you are conceding it, and the Attorney General is also conceding it. Needless to say, if the statement made was false, he also concedes that the judge should have been removed. Now, the third issue is the Supreme Court itself. We are hearing this case. Now the question arises, what sort of order we can pass in such circumstances? And I think there's an interconnected, where is the Attorney General? Attorney General, where is he?
कलर मैं ऑफिस से चेक करवा लेता हूँ ऑफिस में.
बुला लें अगर उनको.
खान साहब जरा ये ओपिनियन तो पढ़िए पेज 70 पे. So opinion of the Supreme Judicial Council.
Yes.
Page 70 पे.
70 पे. Yes. Conclusion, sir. This council is unanimously of the opinion, kindly see here, that in the matter of making his speech before the District Bar Association Rawalpindi on 21/7/2018. Mr. Justice Shoukat Aziz Siddique, Judge Islamabad High Court, Islamabad, had displayed conduct unbecoming of a judge of a High Court and was thus guilty of misconduct, and he is therefore liable to be removed from the office under Article 2096 of the Constitution of the Islamic Republic of Pakistan. 2096, which says you inquire into the matter, which was never done. The other portion of this, your Lordship may find very relevant, is on page 4950, where they decided to dispense with the inquiry.
इसमें सवाल इसमें ये पैदा होता है, ये सवाल है कि सपोज एलिगेशन दुरुस्त है, सपोज क्या ये जिस तरीके से एलिगेशन बयान की गई है, जिस तरीके से क्या ये एक जज के लिए मुनासिब था? ये तो ओपिनियन उनकी ये थी कि चूंकि ये कर नहीं सकते थे।
सर, इसमें हुआ ये, there was only one hearing camera done, nothing else was
ये
never
तो
done.
डिनाइल नहीं आपकी तरफ से कि तकरीर हुई थी,
जी
तकरीर हुई थी, ये डिनाइल तो नहीं है।
नहीं
नहीं
वो ये
तकरीर का डिनाइल नहीं
नहीं सर, तहरीक का डिनाइल नहीं है।
बट देखिए देयर आर टू काइंड्स ऑफ स्पीचेस ना, आई मीन क्या इज अ जज नॉट अलाउड टू मेक अ स्पीच?
Yes.
देखिए आई थिंक वी शुड नॉट फॉरगेट द फैक्ट्स. The fact is not making of the speech. If it's making of the speech, then probably half the superior judiciary will have to go home, because how many judges have made to the Bar Council's speeches? I mean, these are not too. So
That speech was made before a bar
No, no. So it's not a question of mere making of a speech. It's the content of the speech. I think both go together. Now it depends what I say. If I say there should be, I go and tomorrow I make speeches, independence of the judiciary, this, that, the other, fine. I may even canvass a view which is different. But if I make allegation against someone, so I think you can't disconnect the two things. It's the nature of the allegation. Because I would say if otherwise, then we will have to read that Article 19 is not available to judges.
Yeah, that's what they.
I mean, okay, you may not agree with the judge's point of view, fine. I mean, but you remove him on that ground. The code of conduct doesn't say you can't make a speech. So on it, I don't think there's anything wrong per se in making a speech. Now, if you make some speech and you attack, launch a vicious attack or loaded attack or whatever you want to call it, that we cannot disconnect with it. We have to read it, see it together. I mean, I can't just say, oh, making of a speech. I mean, making of a speech is your right. Anybody's right.
And addressing
I mean, it's not exactly.
District Bar Association.
By the way, you may be interested to know the United Kingdom, which is so conservative, judges give interviews. I mean, House of Lords. I mean, those restraints have far gone, and judges of the American Supreme Court, as judges of the Supreme Court, Justice Stephen Breyer and Justice Scalia's debates,
All make public.
Debates were pretty vicious on various law schools they were given. So let's connect it with the speech. Now, nobody's taking us to the next level. What do we do? Can we personally ourselves inquire into the matter?
Sir, one thing which I just want to point out, there were a number of speeches made by Justice Kiani which was published.
I agree with you on that.
Very clearly.
No, I agree with you. It will be, I think it is connected with the content. भाई अगर आपने बिला वजह ऐसे इल्जाम लगा दिए to another I don't want to use the word institution, but it's important,
yes,
whatever department of the government आप कह लें, जो भी आप कहना चाहें. So naturally, it is not a nice matter. But if they are true, it changes, I think, the complexion of the matter.
Sir, page 70 अगर देख लीजिएगा, this is
solution मैं आपको ही नहीं बता रहा.
नहीं सर, solution तो ये है कि इस वक्त ये जो order है president का, based upon the report of the Supreme Judicial Council, need to be quashed. Unconstitutional.
देखें, Hamid Khan sahab, it's not so simple. Then we'll be faced with an allegation that the Supreme Court threw Khwaja Saab's clients under the bus and saved one of their own. Again, we have to be very fair to both sides because you made allegation targeting specific persons. So if we quash it, that means, effectively means that all that you said was true without an inquiry, one way or the other. Now, how can we, what do we do then?
So then the answer can be, I'm just making a humble submission, that let this order of the president be quashed, let the report be also quashed, and let the matter be remanded back to the Supreme Judicial Council to hold an inquiry.
Can this order be passed?
I believe so.
हमें assist करें
लेकिन अगर सुप्रीम जुडिशियल काउंसिल बगैर इंक्वायरी के रिकमेंड कर देती है रिमूवल ऑफ
okay, are you saying it's inherent in fundamental rights and due process?
Yes.
Power of remand, can you remand the matter to the Supreme Judicial Council?
and that can be consequential on the requestment of the order. It can be
ख्वाजा साहब आप क्या कहते हैं इस
there are
point पे?
two ways.
नहीं, let's see, ख्वाजा साहब is a senior counsel, let's see what his view is. Can we remand the matter to the Supreme Judicial Council or we can't?
My Lord, may I very humbly make a submission? It cannot be done because now there is nothing for the Supreme Judicial Council to inquire into because the petitioner's tenure has already expired. He's no longer, it goes back, he would no longer be a judge to be considered for purposes of removal, which is the function of the Supreme Judicial Council. So it does not fall within the functions of the Supreme Judicial Council at this stage. This is what my very humble submission.
So what is the solution? None?
This matter requires the determination or
No,
not?
let's suppose we, for sake of argument, don't take it amiss, that we set aside the order.
Your Lordship.
That means that that's implied in the order that all that he said, the judge, when he was a judge, was true. So you are condemned. Won't you be condemned?
It doesn't imply that, my Lord.
Why?
May I very
Then you
humbly-
say everything I said was true, therefore the order was set aside?
Yes. What he said, my Lord, so far as the allegations against specific persons are concerned, they came up for the first time before the Supreme Judicial Council.
No, he's been saying it from day one.
No, he hasn't. He hasn't. The specific allegations against persons, by naming them and naming the incidents also, they never figured in the speech, they never figured in the preliminary reply that was given to the Supreme Judicial Council. It was in the second reply, the additional reply that...
No, but one way or the other, why didn't the Supreme Judicial Council say something on it? They could have asked him, say it on oath.
Yes. What did the Supreme...
I don't know, I called you to cross-examine him, I don't know, whatever way.
I'll make a submission. What the Supreme Judicial Council did was, they asked for the then Chief Justice of Islamabad High Court for his reply on the allegations that were made by the petitioner vis-a-vis him. And he denied all those allegations.
But it's one denial,
I'm just making
one assertion.
Yeah. No, but more importantly, may I make a submission? I'd said that before also, and I'm trying to be as balanced.
See, you can't just say because he's Chief Justice, I believe him, and because he's a simple judge, I disbelieve him. That's no...
Now we come back to the speech itself. The sole ground on which the matter against the petitioner could have been sustained, this order can be sustained, is if this Honorable Court comes to the conclusion that that speech per se was sufficient for his removal because it came within the definition of misconduct.
Are you suggesting a judge cannot give a speech to a bar counsel?
No. What I'm making a submission. May I make a mistake? Irrespective of whether it was true or not what the petitioner said, irrespective of that, because it maligned the judiciary as a whole.
How does it malign the judiciary?
Let's go through the speech itself, if your Lordship would.
No,
and it maligned the Army Institute, the armed forces.
He is maligning you.
No, not in the speech. In the speech, it is the armed forces, it is the judiciary. They are the judges of the Islamabad High Court.
Suppose the allegations are true, then what will happen?
Even then, the petitioner should not have gone public or made a speech before the bar.
Why?
He could have issued a contempt notice.
Why are you saying he should not? Unless you can specify some violation of some law, constitutional provision, or a constitute of the code of conduct of judges, you can't just say he should not have. You should refer to something because of this reason.
The code of conduct says something to...
Refer to that provision which says that judge cannot give a speech to the bar counsel. counsel or
It's not a
whatever.
question of giving a speech, it is a question of giving a speech which maligns the judiciary.
Exactly,
in
it's the
public,
contents of the
or
speech.
which maligns any institution in the country. That is
Okay, now let us.
Only that has to be held.
एक second, Khan Sahab, एक second. Please refer to the code of conduct. Code of conduct मुझे निकालने. Which provision are you relying upon?
But may I very humbly submit, my lord, I am not taking sides in this case.
No, I know.
Because your lordship has called on.
No, actually, देखिए, it's always beneficial to have a senior counsel like yourself.
I'm just
because we are just thinking aloud how to proceed.
yes.
And we'll be next be calling upon the Attorney General as well. So, which possible misconduct provision can you bring him under?
There's one provision in the Code of Conduct, Hamza, which relates to public speech.
Article 2 up. Maybe you can read Article 2.
I'll read that and then I'll read Article 2 for your lordship, my lord, but I think there's another provision which talks about, this number 5. Yes, it's Article 5. May I very humbly submit? If it is to be stressed, it will fall under Article 5, nothing beyond. I will come back to that also. Functioning as he does in full view of the public, a judge gets thereby all the publicity that is good for him. He should not seek more. In particular, he should not engage in any public controversy, least of all on a political question, notwithstanding that it involves a question of law.
It's not
It's
a
not
political system.
it's not publicity he was seeking. He was, let's call him a whistleblower. Every whistleblower, you will say is seeking publicity. What publicity he was seeking by this? You are assuming he was seeking. Burden will be on the person seeking his removal to show that he was seeking publicity. It's premised on that. As a judge gets all the publicity that's good for him, he should not seek more. So then it will be you are seeking publicity. In other words, you can't address bar councils. Yes, there'll be the media there. So what?
May not engage in any public controversy.
No, it says least of all on a it's not the public, it says political question. Where is politics here? There's no politics here.
It states in particular, he should not engage in any public controversy,
So if
least of all on political matters.
let's take the worst case scenario. If the institution he is in, there is corruption, he should keep quiet.
No, there is.
So what should he do?
He should be writing to the Chief Justice.
Okay, he says
He should
failed.
be writing to the,
Failed.
And if there is somebody,
Then what should he do? He should keep quiet about
if
it.
there is someone approaching him, he has the power. He can issue contempt notice to that person. If anybody dares to
there's
approach him,
corruption, there's
to
no
influence him in any of his decisions.
There's corruption, for instance, not this case, we're giving a simple thing.
What I'm saying, Lord, is that
His colleague is taking a bribe.
Lord.
He writes to the Chief Justice, he informs the Chief Justice, he doesn't do anything.
Lord.
He gets frustrated.
Lord.
Okay? Maybe the frustration level comes to a point that I'll go public now. Okay? So, fine. You can, the person against whom he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case.
Lord, may I?
So which other article can you rely upon?
This is the only article, I suppose, my Lord. There is an article which was invoked in the order itself.
Which one was
And
that?
what I'm saying is,
Kindly read second para of Article 2.
I'm going to read that. Right. Second para, should I?
Second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity of the court, while maintaining an equal aspect towards all litigants, as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes.
Yes.
This is all. My Lord, I think
You are saying it comes under this too?
Lord,
What's your
what I'm saying is that these are the provisions which can be.
No, tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because, my Lord, from
we have an advantage in having you before us.
My Lord, I'm grateful for
ठीक है,
your
so
lordship.
the advantage is you are now well versed with SJC matters. Okay. The other SJC matters where you are proceeding again. One is finishing a complaint, right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where you proceeding against a judge? Why you proceed against a judge? With a view to remove him. So you have to give him some. I mean, here you may be conflicted as a lawyer. I'm not saying conflicted in this case, because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट। जो एलिगेशन इन्होंने लगाई है वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आपसे पूछे। उन्होंने एक तकरीर में कर दी। दूसरा तरीका आप बता दें कि कैसे कर सकते हैं।
उसका तरीका मैंने बताया ना, जो एलिगेशंस लगा रहे हैं व्हाट इज I am again, let me reiterate, I am not taking sides. I am saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there's nothing beyond that. Article 5 or at the sub-para 2 of Article 2. And this is for this Honorable Court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So they were, and those specific allegations are not there in the speech. The order itself, when we read page 7, we read the conclusion, it is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired into. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going to saying is going back to the observation.
Is it the status which?
No, not at all. Not at all. It was just, I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something, therefore believe him and not believe the other part. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, this is fine, this is all right, this does not amount to misconduct, then the order that this Honorable Court has to pass, the way to move forward, is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be.
But if you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without an inquiry. I've already said that is part of the order itself. Okay. What the conclusion would be then that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this Honorable Court wants to go into whatever the petitioner it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. As far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. If the allegation level is true, I mean, the nation wants to know the truth of the matter. this person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Don't you, let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, what would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How will you get to it?
What I'm saying is that not in this list, not in the case before
How
your
do we do
lordship,
it?
that your lordship takes suo moto action or takes some other action, but not it cannot be within the ambit of-
one इनकी एक तजवीज़ आई है कि
Bismillah.
to remand it to the Supreme Judicial Council that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with? Result? Who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको solve करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he is sticking to that the matter can go back to the Supreme Judicial Council.
Can it? ये
I see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of that of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge, or as in this case by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he's removed, recommends to the President, remove him. That's it, end of story.
The petition is here for the purpose of getting it quashed precisely for this reason.
नहीं, quash की बात तो नहीं आएगी. I'm saying that is the one person, but this is not a matter of one person. It's a matter of the independence of the judiciary, which the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Who was telling the truth? Well, truth doesn't matter anymore. I keep emphasizing on truth. If he's truth, I think all the maslas will go away.
Just as it was open.
Aren't you personally interested just to know?
No, yes. May I make a submission?
Isn't it burning inside you?
But not within the framework of law, within the framework of constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame. I do not see
which provision prohibits such an order. I'm just thinking aloud.
ये जो केस है आपके पास
नहीं ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, कंप्लेंट हमारे पास पढ़ने नहीं बहुत सारी पड़ी हुई है, आती जाएंगी, मुझे कोई जज नहीं पसंद है, मैंने कहा चलो हटा दो इसको, सारे हमारे सुप्रीम जुडिशियल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते हैं.
पिटीशन आती है, एक पिटीशन.
अगर देखिए एक बात है substituting your opinion for someone else, that's a different matter. The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. I mean, even if someone commits murder right in front of 100, 200 people sitting in this room, we can't just say hang him. No, we'll have to frame a charge, we'll have to bring witnesses, we'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, like, each decision creates a precedent. So where should we go now from here?
As I keep saying, my lord, the order gets quashed if dishonorable bench comes to the conclusion
then the nation will hold us accountable.
Necessary, notwithstanding the allegations made. It was,
If you have finished, can we request the Attorney General?
Please.
Huh?
Yes.
Okay.
I made my submission.
Have you understood, because you came in late? Let's just quickly recap everything. The petitioner made allegations in a speech to a bar. One is, you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was so, whatever, it was not pleasant for someone or the other, and nonetheless it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahib has said, is finds mentioned twice, 5, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. ये इसके तहकीकात होनी चाहिए या नहीं होनी चाहिए, बस हवा में उड़ा.
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now, we were hearing some other case.
Yes.
The same issue came up there also.
So, my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition is concerned.
Which ouster?
211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments you said.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide in law.
No, but malafide in law is basically if the process is not followed. If what the law or the constitution requires is not followed, it is malafide in law. Not in fact, but in law. So because if that is so, then this court has jurisdiction, so the court can proceed. The court can look into the movement.
We are not a substitute for the Supreme Judicial Council.
Of course you're not, but now the question...
We can't say, okay, now please come and give oath and give it on statement,
this is
will cross-examine.
No, this is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter, but I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been
crossed that bridge.
So yes. So once that is done,
where do we go from here?
Once that is done, now one fact which was alluded to, and there's a judgment, a two-member bench's judgment in Afia Shehrbano Zia's case, BLD 2023 Supreme Court 510, wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, while he was on the bench, had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord, it has been filed.
क्या number है?
My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course,
if the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
now, so in this,
If in the meantime he retired, for instance,
so in this
he
case-
attained the age of superannuation.
so in this case, the distinction also is that after the judge was, the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that judgment needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case also.
Yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Acha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
Is remand permissible?
if my lord,
If you are saying if afia is sustained, then it probably may not be. Is that what I'm not understanding?
if afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that
No, but
distinction.
I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this particular case.
If we accept this petition,
Yeah.
what will happen? So we'll simply
Things can happen. Two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who had retired.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing. All that I said was false. Okay? Nation, I think I'm more concerned that every case we decide we have to keep half an eye out कि भाई इसका implication generally क्या होगा. You may want to do something, but it may have wide ranging implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Wouldn't you want to, as they say, get to the truth of the matter?
My lord, so I just got called on short notice, but
I know that's not fair.
What I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been
Serious
denied.
allegations, not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence, is not the forum for doing it.
Is there a solution?
The solution, my lord, is that in order to look at the entire matter in totality, if Afia Zia is overturned and this matter is remanded to, the order of the Supreme Judicial Council is set aside and the matter is remanded to Supreme Judicial Council, then as far as the inquiry of these allegations is concerned, that perhaps is the only forum.
And then question arises that the man has retired. What will happen?
So for that purpose, you have to overturn Afia Shehrbanu Zia. For those purposes, you have to first, this court has to overturn Afia Shehrbanu Zia in order to cross that barrier and then go to the...
This case is slightly different. He was not retired at that time.
That's right. He was still before the court. Now the question would still be that if the petition is allowed, what could be the consequence? Now if limited consequences,
जल्दी डिसाइड हो जाती है इनकी रिटायरमेंट से पहले तो मसला हल हो चुका
वो भी हो चुका होता, बट अगर फॉर एग्जांपल एक ये हो सकता है कि जी पिटिशन आप अलाउ कर दें एंड he is treated as a retired judge and thus entitled to all the benefits which a retired judge is entitled to. But if on a broader scale, so on a broader scale, then I think since he has retired and now that
that is what's troubling me. Let's suppose a complaint is filed against a judge 1 month before his retirement. And the Supreme Judicial Council, without saying he's corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports, whatever, remove him. He's removed. Now, naturally, when he filed the petition, he's already retired.
That's right.
So I don't think the date would there be. He has got no way to vindicate his honor.
There has to be a way.
Basically, you are saying one way is no, too bad, whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Judicial, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without inquiry.
Are judges entitled to fundamental rights or not?
Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has
इसका solution क्या है फिर?
So इसका solution, to my mind,
आप
is
कह रहे हैं कि इसको क्लब करें उस केस के साथ?
उसको overturn करना जरूरी होगा because that would then settle the law. Because in this case, obviously, there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And his
Nobody could have
superannuation.
thought this would connect there.
About 3 years.
So if he had 3 years to his service left.
No,
and,
Dekin, like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then obviously.
I don't think that's really crucial aspect.
So in that hypothetical, which my Lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by.
Because that delay we are accountable for in this particular case. Because it's proceeded so long. We can't fault the petitioner on that.
Oh, absolutely not. Nobody can.
So, कितनी hearings हो गई थी इसमें?
बेशुमार sir. Many hearings.
हमने कितनी दफा सुना?
Last hearing was.
मैंने कहा आपका इल्जाम हम पे तो नहीं है. हमने कितनी दफा सुना इस केस को?
ऑर्डर शीट दूसरा मैं आपको ऑर्डर शीट दिखाऊं तो
ये दूसरी दफा है. हम मेरे साथी याद दिला रहे.
But we are responsible for our seniors.
अक्टूबर 2018 में ये पिटीशन फाइल
2000
ना नहीं वो क्योंकि वो पार्टी नहीं बनाया था ना उसमें भी टाइम लगा. वो आपका कसूर था खान साहब. थोड़ा हमारा कसूर था मगर वो आपका कसूर था मान लीजिए. क्योंकि आपने एलिगेशंस लगाई थी against people who were not before us. So we had to give them a notice. So that goes in your, we don't accept responsibility for that.
But the question that even shows that this was a case.
Wasim Sajjad Sahab, can we benefit by your acumen? Have you been following what we are talking about? What is your view? Can it be remanded to the Supreme Judicial Council or not?
But actually, I haven't studied this matter. I wouldn't like to make a comment without going through studying it properly because it's an important question. But I would say that the Supreme Court of Pakistan is the highest court, and there's nothing in the Constitution which prevents it from remanding the case back to the Judicial Council. But as I said, I would like to study the matter further. Once the matter is before your Lordship also has the power to do complete justice under Article 187. So there's no impediment.
आपकी अपील कब लगी है?
My Lord, it's been filed earlier today. I think it will hopefully be numbered today. And once it is numbered, I think it can be fixed whenever the office will fix it.
Point that you want to say at this juncture? Anyone, any of the council or?
This is one of the exceptional cases. Earlier cases, like Justice Shoukat Ali's case, there was a detailed inquiry held. And after that, the Supreme Judicial Council submitted to the President to remove him. There have been even earlier cases, Ikhlaq Hussein's case, where inquiry was held. This is the first case of risk nature where no Supreme Judicial Council did not hold any inquiry into the allegations. So therefore, my submission is this goes right against the independence of...
No, can you cite those cases, the earlier cases, where inquiries were held?
One is Justice Shoukat Ali's case is PLD 1971 Supreme Court.
1971 Supreme Court,
page 585.
585. And here you are saying the Supreme Judicial Council did hold inquiry.
Hold a very lengthy inquiry, some 80 witnesses and so on. So
recommended the judge's removal. And in the next cases, this is Justice Shoukat Ali.
Earlier case was Justice Ikhlaq Hussein's case, PLD 1960 Supreme Court. Yeah, page there now, 26 perhaps.
जी
अच्छा उसमें
नहीं वो पेज नंबर अखलाक हुसैन हम ढूंढ लेंगे चलें खैर अगला वाला बताते हैं कोई और भी केस है
ये दो केसेस हैं जहां पर सुप्रीम कोर्ट जज वाज रिमूव्ड आफ्टर ड्यू इंक्वायरी। नाउ सर एक और बात 1956 का मैंने कॉन्स्टिट्यूशन देखा है उसमें कहीं इंक्वायरी की रिक्वायरमेंट नहीं थी एज सच बट inquiry was held.
Which was that provision of 56 Constitution? Which article?
Earlier article was 128.
128.
60, under the 60.
Article 128, Supreme Judicial Council, which did not specifically mention the word inquiry.
It mentioned inquiry. Article 128 was in the same terms as Article 209. But I'm talking about 1956 Constitution. Under the 1956 Constitution.
किसमें नहीं था?
ये इसमें नहीं था